Okay, we're back on the record in Church v. Johnson. So, following the evidentiary hearing, the court heard 8 days of evidence ranging from March 7, 2022 for a half day, March 8th, 2022 for a half day, April 20th, 2022 for, all of these are 2022, April 20th for a half day, April 25th, half day, May 11th for a half day, May 12th for a full day, May 16th for a half day, and day 8 was June 15, 2022. The court heard a lot of evidence. What I did not, I may have missed it, but I don't recall hearing any or seeing any evidence that the child cannot or should not be around Mr. Hansen, mom's boyfriend. There was some kind of rumor somewhere. I don't know, somebody said that Mr. Hansen's a member of Hell's Angels. I just heard a statement to that effect. I don't have any evidence to suggest that that is actually true. Also, I heard an assertion that Mr. Hansen was honorably discharged from the Marines. But I didn't have any evidence of that. So those are just statements that were made. I don't know one way or the other. The court obviously was very disturbed when Mr. Johnson was shot outside of his home, and during the trial, and that happened in March. Obviously.
Your Honor, I'm so sorry. Richard is disconnected. He wanted me to let you know.
Oh, thank you. Thank you, Ms. Church. You're right. So he's going to log back in. So could you find him and bring him back over?
Yes, sir.
Thank you, Ms. Church.
Your Honor, he's back in.
Okay, thank you.
I'm back. Thank you, Your Honor.
Okay, thank you. I'm sorry, I don't know when we lost you.
Your Honor, we were recapping the days of the trial when I got disconnected.
Okay, I was saying I didn't have any evidence, just arguments or statements about Mr. Hansen's involvement with the Hells Angels, and also that he was honorably discharged from the Marines. So I don't have any evidence of why the child should not be around Mr. Hansen. It was disturbing that Mr. Johnson was shot. That was in March. It is now November, and so 11 minus 3, 8 months ago, and to my knowledge, there have been no arrests. I suppose the investigation is still ongoing. I've not heard anything to the contrary. So Mr. Hansen and Ms. Church were not ruled out as potential defendants in that, but I believe the detective, Metro detective, who is investigating that attempted murder, stated that they know for a fact that Ms. Church was not, definitely did not pull the trigger of the gun. And so that was the one thing that they were able to testify conclusively about. But it has been a very, very long time that this child has been separated from her mother, with the exception of supervised visits, and the court had grave concerns about Ms. Church's mental health at the onset of this case, especially in that the court ordered her to attend options for drug testing and drug treatment, but she stopped doing that on her own, and the court found her behavior to be bizarre, especially at the initial hearing back in, I believe it was, I'm going from my memory now, April of 2021. I could be wrong on that, but The court even reviewed that hearing video again, just to double check the court's memory as to why the court had so much concern about Ms. Church's bizarre behavior response. But all of that has been fleshed out. Ms. Church has undergone I believe it was the assessment, the evaluation that the court ordered.
Judge, may I make a comment about Mr. Hansen?
You can make it quick, but I don't want any argument. If I'm gonna give you my decision here, I don't wanna have to argue about it too.
I understand. I just wanted to point out that Mr. Hansen, in the evidence at trial, was found to have been substantiated for abuse and neglect regarding the incident where he pointed a gun at my client, and he also was convicted of that crime.
That is true. You're absolutely correct. Thank you for that.
There's a substantiated abuse and neglect on the minor child in this case.
That is true. You're absolutely correct. Thank you. I do appreciate you stepping in and reminding the court about that. That is true. At the conclusion of the evidence, Mr. Schoenfeld, on behalf of his client, asked the court for joint legal custody, joint physical custody, and to remove the protective order, to have, I'm sorry, re-implement, I don't know what, daytime unsupervised visitation, I believe, overnight unsupervised visitation. I removed the suspension of the supervised visits. That's in my notes, but they're not very... and then, let's see, Dad asked for joint legal custody, and for Dad to have primary physical custody. The joint legal custody is with sole decision-making regarding medical decisions, and to continue the visits in place. Failure to complete and then child support award. All right, so with respect to what you just brought up, Ms. Cole, you're correct. There was, during the pendency of this case, Mr. Hansen was charged. The court also found Mr. Johnson's behavior and that of his girlfriend by going to the tattoo shop as somewhat antagonistic. That does not excuse Mr. Hansen's behavior for pointing a gun at Mr. Johnson at all. That does not excuse that behavior. However, it was provocative and antagonistic for Mr. Johnson's girlfriend to go into the tattoo shop and for what she called or referred to as a well check. It did not seem like that. It seemed more like she was the girlfriend, which acting as an agent of Mr. Johnson, was antagonistic in shouting out things to the child and trying to cause chaos. That did not go over well. That was not a good move on Mr. Johnson's behalf. So the court and nothing to that has occurred since then, everybody seems to have calmed down a lot, other than the attempted murder of Mr. Johnson, which, for which the suspect is still outstanding. And the court is very concerned about that, but the court has to balance that concern with this child's need to have a relationship with her mother and contact with her mother, and from based on the evidence that the court has seen and reviewed, the child has a very strong bond with her mother, and the two of them have, like I said, a strong bond, and the best. Let me just go through the best interest of the child factors very quickly. All right, pursuant to NRS 125C.0035, subsection 4, in determining the best interest of the child, the court shall consider and set forth its specific findings concerning, among other things, A, the wishes of the child if the child's of sufficient age and capacity to form an intelligent preference as to his or her physical custody. This factor A does not apply. The child's too young. Factor B does not apply. Factor C, which parent is more likely to allow the child to have frequent associations. Initially, the court was thinking that this factor would weigh in favor of dad, but as time went on, mom became more reasonable, it appeared to the court, and it seemed to the court that mom went through a process of complying with Nevada law in co-parenting. The court may be mistaken in that respect, but that was this court's observations. So the court believes that the parties are working better now. As far as the court knows, of course, mom's visits are supervised at Donna's house, but the court finds that this factor is neutral. But I mean, also the court acknowledges all of the evidence where both parties would withhold the child from one another. The court is aware of all of that, but both parties, there was a period of time when both parties were not were not co-parenting well at all. D, the level of conflict between the parents. At times, this has been extraordinarily high, but things seem to have calmed down. I don't know if that's because I just haven't heard any evidence of what things that have been going on, which is appropriate, but also mom's only been restricted to supervised visitations, but I believe this factor has been, it's neutral as to both parents. Factor E, the ability of parents to cooperate to meet the needs of the child. Court finds that this is neutral. Both parties have demonstrated inability to cooperate and meet the needs of the child. Again, hopefully things will have calmed down, and maybe the court is hopeful that the parties can cooperate to meet the needs of the child. And remember the needs of the child over the party's own emotional feelings towards one another, which is very highly charged and not positive. The mental and physical health of the parents. We have talked about this. Mom underwent a psychological evaluation by Dr. Sunshine Collins at the order of the court, and Sunshine Collins found that she does have a diagnosis of delusional disorder, and mom has, based on representation by her counsel today, has gone to see a psychiatrist, Dr. Suba, S as in Sam, U, B as in boy, A, middle name Park, P as in Paul, A-R-K, last name Cheng, C-H-E, CHE, N as in Nancy, G, with the group called Alliance Mental Health, and mom had a substantive appointment, and that the Mr. Schoenfeld is in the process of sending the report from Dr. Collins to the to Dr. Chang. And so mom has already begun the process of following the court's orders and following the advice and treatment recommendations for the delusional disorder. Mom has also taken a drug test recently on November 1st, 2022 for hair and urine. Was it hair and urine? I haven't looked at this. It says type urine.
Yes, it was hair and urine.
Okay, all right, thank you. And it was all came back negative. And mom did produce earlier on the reports from ATI showing that her drug tests were negative. The court did not find a lot of value in those drug test reports because those drug tests were not pursuant to the court's order. Those drug tests were taken at mom's her own decision at the dates and times that she decided, so the court was less assured of the reliability of those results, even though the court did hear testimonial evidence from both options and ATI, and all of the options reports that mom for drug testing, for the patch program that mom submitted to, they all came back positive for meth and whatever else the other substances were, and those reports will speak for themselves. They can be included in the written report today, the written order from today. But mom seems to be testing, at least for the one test that she did here, she is tested negative, and throughout the 8 days of trial in this case, sometimes mom, at the beginning, mom was far more passionate and argumentative and hostile, I would say, but towards the end of the trial she was more calm, and perhaps the process just wore her down. I don't know, but mom's behavior does seem to be less agitating, what's the word? Something having to do with that. The physical, developmental, and emotional, so the mental and physical health of the parents. Dad also has a criminal history, impressive criminal history, and the court's so the court finds that this and that's not necessarily mental and physical health of the parents, but it is it has to do with dad's past, but hopefully that activity is in dad's past. Both parties have a history of drug use, and the court is aware about the incident in Michigan where mom alleges that dad left her for dead in the woods, and but perhaps the court only can suppose that there had to have been some kind of drug usage or something that was involved in that very bizarre story, but that was a long time ago. The physical, developmental, and emotional needs of the child. This child is extraordinarily intelligent and very mature for her age, and is very eloquent in her speech, very developed in her speech patterns and communication skills. This factor is neutral. H, well, and also I said F is neutral. H, the nature of the relationship of the child with each parent. Um, uh, if anything, I think this factor is neutral. The child has a great relationship with mom. The court did not see a lot of interaction with dad. However, the court has no reason to believe that the child does not love her father as well. Factor I, the ability of the child to maintain a relationship with any sibling. My recollection is that neither parent has any siblings in their home. So that's neutral. K, the domestic violence against the child. Mom has alleged over and over and over again that dad is sexually molesting the child, and that dad's boss is sexually molesting the child, and dad and mom's mother is sexually molesting the child, and that dad is involved in a child pornographic ring and other bizarre activities, but mom provided no evidence or proof to substantiate her beliefs, other than just her beliefs, and the child has had to undergo at least 2 forensic interviews and a physical exam, which is disturbing to the court, and no evidence was found to substantiate mom's allegations, which was largely led to the diagnosis of the delusional disorder. And domestic. There's a lot of hostility and bad actions between the parents when they were together a long time ago. I think we can all agree their relationship was toxic. And I don't mean that as a clinical diagnosis. That's just a layperson's assessment of how the parties were able to get along with one another. And then L, whether either parent or any other person seeking physical custody has committed any act of abduction. It could be argued that the withholding of the child from the other parent could be an act of abduction, but neither party permanently removed the child from the state and concealed the child, took off with the child. So I'm going to find that L is neutral. But going back to K, the domestic violence, and also abuse or neglect. I think the abuse or neglect being the allegations by mom of dad's sexual misconduct with the child. There was no evidence to substantiate that, so I'm calling J a neutral, and K, whether either parent or any other, that's the domestic violence. I think that this one can cut both ways based on the evidence that was presented to the court, so I'm calling that one neutral as well. So therefore, after analysis of the best interest factors, the court finds that it's in the best interest of the child for the court to award joint legal custody and joint physical custody of the child, with week on, week off timeshare, with exchanges being on Fridays after school. If there's no school, then 6 p.m. on Fridays. And I believe the parties are still currently using Talking Parents or some other parenting communication application, and so that will continue. There will be no contact between Mr. Hansen and Mr. Johnson ever. Of course, I don't have any jurisdiction to make such an order of Mr. Hansen, but I do have jurisdiction to make orders of Ms. Church, so it is your obligation to ensure that they do not come in contact with one another.
Understood.
Thank you. And
Thank you.
Judge, may I say something?
yes,
Your finding that of the frequent associations between the parties being neutral, Miss Church testified for 2 days that she doesn't want the child anywhere near my client because he sexually molested her. And when I asked her
Ms. Cole,
if she would return the child, she said no.
This is the kind of, she did, and that was terrible. And I think that if you were to ask her the same question now, she would change her mind. Because
She hasn't.
she asked for joint physical custody, which belies her request for when she was arguing that she would not allow dad to have. I agree. So based on,
I understand, but she's been.
Ms. Cole, please. I heard everything. I was right there. And I believe that when she said that, we already know she has a delusion disorder. And she's aware of that now. She asked for joint physical custody, which means that she's acknowledging that the parties can have, the parties will exchange the timeshare. And if she does not comply with the court's orders, I expect you to come running back to me for a motion to modify.
Okay,
if she does
just-
not comply. But
Okay, Miss, that's fine. But you saying that Miss Church appears to have relaxed. She has not even had a chance to say much because she's represented by counsel. That first hearing, she was pro se.
That's true.
So she's barely even spoken to the court.
Ms. Cole,
She failed out of the options program and never
Cole,
even went back.
Ms. Cole, I know. She didn't, and the court is aware of that. And she also provided negative. I've already said all of this.
One.
I've already addressed all of this.
The one test,
Your
and
Honor,
she's.
I had understood that we weren't going to have argument.
Yes, I understood that as well.
I'm sorry. I'm in shock right now.
You can file a motion
I apologize.
to modify. You can file a motion to modify if something happens. If she doesn't comply with any of these orders, I would expect you to come running back to court, and I will consider your orders very carefully because this decision does not come easily. This was a very, very tough case, but
How do we even know if she's clean from drugs? There's no drug monitoring for her after she didn't even complete the options program?
Ms. Cole,
There's no continuing oversight? How would my client know
Mr.
if she's
Schoenfeld, Could you
clean?
please prepare the order, include the court's findings, and I will give you 6 weeks to do it because we're heading into a whole bunch of holidays. So, more than 6 weeks.
Will
I'm
do.
thinking
Thank you.
January. Let's see, January the 15th. Can I have the order by January 15th? If I don't have it by January 15th, oh wait, that's going to be a holiday, isn't it? And that's a Sunday also. All right, let's make it January the 9th. So January the 9th, if I don't have the order by January 9th, then the parties can come back at 8:30 a.m. on January the 9th. And for a status check regarding submission of the order. Of course, provide it to Ms. Cole. She can have more than 7 days because she can have 2 weeks to review the case, to review the order. And if she needs additional time, please grant it. And then at the status check, if you need more time, just let me know.
Understood.
The target date is January the 9th at 8:30 a.m.
Judge, can my client
No,
have
the
random
first
drug
exchange
testing
is-
once per month? I'm sorry, I was talking. Can my client have random drug testing at least once or twice a month? Can we have an update? She hasn't even gone and been treated by a psychiatrist yet. How do we know that she'll follow through?
She's in the process of doing that. Mr. Schoenfeld indicated that he's going to provide that information, and I hadn't finished. I would like for Mr. Schoenfeld to provide, at least for 6 months. I'm going to close my case, but I want you to provide for 6 months, once a month, some kind of proof that mom is attending her sessions with Dr. Cheng, and that she is complying with the treatment recommendations of Dr. Cheng. I don't need the reports of Dr. Cheng, just some kind of documentation indicating that she's showing up for regular appointments and that she is in compliance with Dr. Cheng's or whoever her psychiatric treating physician is going to be going forward, that she's in compliance with the recommendations of the doctors. And then the court is also going to request periodic submissions for drug testing. If Dad can request a drug test up to 3 times within the next 6 months, and that's going to be 6 months after notice of entry of order. So these orders are ongoing starting now, and up to 6 months from the notice of entry of the order that's going to be prepared by Mr. Schoenfeld. So Dad can request the random submission of drug test, and he should email it, or no, he can do it through the Talking Parents app. He doesn't even need to go through the attorneys. But if mom and mom, he has to give her the notice no later than 10 o'clock in the morning, that she needs to go to the drug test by that later on that day. I don't know that I need an actual order. Mom, do I need an actual order? I mean, for her to take to these drug test facilities? I'm not sure. I'm trying to get the court.
If the order says that he can give her notice, then she has to go down and get a full screen urine and hair.
Yes.
Then she can take the order with her to show them that and the notice, I believe.
Yeah.
Also, if I go down to the testing center, what they can do is just email the results straight to Richard, and I won't receive them. And then that's how they were being held to be used in court that way. So I wouldn't have any of the results or anything. They would just send it straight to him.
All right, we can do that. And also,
What?
I did want to make a note too. Is the court was concerned that, I mean, I definitely acknowledge hair color for people, but Ms. Church does color her hair quite a bit, and we did hear testimony that hair color can alter the results of drug tests, and but Mom's hair color changes frequently, almost every single time that she appeared before the court, which can alter drug test results. So the court does share some concern about the ongoing drug usage of Mom, but also no, I won't even go there.
What about Mr. Hansen being around the child? He's got
I've addressed that.
So he has a substantiated abuse and neglect charge against the child.
I've addressed
So
that.
the child is okay to live with him?
All right, Mr. Schoenfeld, would you please?
Your Honor, once again,
Yes, we're having arguments.
I would ask the court to admonish Ms. Cole that this is an argument. You're rendering your decision.
Yes.
It was a question.
thank
It's
you.
a question that was not clarified.
No, Ms. Cole, it was clarified. I addressed it.
I know that he's not to have contact
Excuse
with
me, I'm not
my...
making any restrictions regarding the child's contact with Mr. Hansen at this time. Of course, if something develops, if something comes up, you have to come right back to court and we'll talk about it then, but I already addressed that issue. So, Mr. Schoenfeld, please prepare the order. With respect to the child support, I'm not, I have not calculated that today. I have not calculated that today. Let me see, we have, well, the last FDF that I have from Dad was dated, December 27, 2021. So, I expect an updated financial disclosure form from Dad within 1 week. Actually, I'll make it 2 weeks because of the holidays. So today's the 22nd, so I'll make it December the 6th. Dad has to file an updated financial disclosure form no later than December 6th, and the court presumes that Mom is still unemployed working with Dad, but the court's going to impute an income to her. I don't know, Mr. Schoenfeld, I think that after Dad provides his financial disclosure form, I would like for the parties to meet and confer about the amount of the child support that should be awarded. There was testimony that Mr. Hansen makes $300,000 a year, and I'm not saying that it's his obligation to financially support the child. However, he is paying all of Mom's bills and is entirely financially supporting Mom, and she is choosing not to work because of that. So I am imputing an income to Mom I don't know. I would need to think about that some more, but see if y'all can work out the child support amount based on the financial disclosure form that's going to be provided by Dad. And then I will make that, and y'all can argue about the effective date will be going forward, but also it will be, there will be constructive child support arrears from the time of the filing of the motion, but Dad has been, it's going to be complicated. If you guys can't work that out, then come back and I will make a decision on that. Just let me know if you can't work it out, and I will know that by putting it back on calendar. If you put it back on calendar, then I will take a look at my notes and the new FDF, and I will make the decision on that. Both parties are ordered to ensure that the child is covered for health insurance, and they'll equally share the cost of out-of-pocket expenses pursuant to the 30-30 rule, and the parties can alternate claiming the child for tax purposes. The child has spent most of 2022 with Dad, so Dad will be allowed to claim the child for all even-numbered tax years, and Mom can claim the child for odd-numbered tax years.
Your Honor?
Yes.
He claimed that as here. I don't know if that's valid. But when I went to file my taxes, he had already claimed her, and I did have her for the bulk of the year last year.
How do you claim taxes with no income?
I was an actress. I'm a SAG member, so I receive SAG checks. They're not much. However, I do have a little bit of things that are going to be on my tax income.
Okay, well, none of that was included in your financial disclosure form, so.
It's probably a few $100s a month, but I was just curious on the fact, if he did claim last year, does that matter, or should we just, did he just hold claim this year and then we'll skip a year?
Judge, the amount of taxes that are paid by Ms. Church is so minimal.
Exactly.
It's not, if she doesn't have gainful employment, why would she even get every other year? I understand if she's working.
I agree. Whoa. I agree. I mean, none of that's included in your financial disclosure form. I have a financial disclosure form from April 20th, 2021 that says that you are unemployed. As far as I know, you are unemployed from then all the way through the rest of the 2021. And so, and you didn't include any of that income there, so no, the tax, Dad's gonna claim the child for even number tax years, and Mom can claim the child for odd number tax years. And so.
But if Mom doesn't have a job, can Dad claim?
I'm also, Madison is on my Medicaid. So I have Medicaid right now for Madison's medical insurance because Brooks took her off his insurance because it was too expensive. So that's another reason.
Okay,
insurance for the last 8 months. 550 months for her for the last months.
Proof from the Talking Parents app in which you told me to keep Madison on my.
Stop, Ms. Church, stop. All right. So Mr. Johnson, you have health insurance for the child through your employment, correct?
Yes, and it's very expensive.
All right, so Dad will ensure that the child is covered under health insurance through his employment, and
Okay.
the parties will equally divide all out-of-pocket expenses pursuant to the 30-30 rule. And
Judge, if mom has Medicaid, why are we making dad pay $550 a month?
because if Dad is making enough money, I mean, if Dad has a job,
He's not.
Dad has a job.
He's not. I went pro bono on this case.
If the parties qualify for Medicaid, then that's fine. Then they can keep the child on Medicaid.
I mean, it seems like the realistic option when $550 or Medicaid is free.
Okay.
And it's coverage. So I just didn't want my client to have to pay $550 when Miss Church is receiving Medicaid for the child.
Well,
If he can't afford it, I mean, if he wants to pay the $550.
Oh my gosh, please stop. I originally said the parties are to ensure that the child is covered under health insurance. And so then that opened this big can of worms. If the child's covered under Medicaid, that is fine. And the parties will equally share the cost of out-of-pocket expenses pursuant to the 30-30 rule. So Dad can drop his health insurance if the child qualifies for Medicaid. All right? All right, so I think that's everything. Court's adjourned.
Your Honor, when would the first exchange be?